Sir, step out of the vehicle. This doesn't have to be difficult.
Officer, state your name, your badge number, and the specific legal basis for the stop. Do it now, on camera.
I'm asking the questions here. Get out of the car.
No, you are not. You are answering them. Badge number, now.
The footage right there, right at that frame. Because what you just heard is not an argument. It is not disrespect. It is a circuit court judge who has presided over 4,000 cases, who has written opinions cited in federal appellate courts, who has spent 11 years studying the exact moment you just witnessed, and responding to it with surgical, documented, legally airtight precision. We are going to break down every second of what happened. We are going to talk about who this man is, why it went the way it went, and why the county he lives in is now $13.8 million lighter. Stay with me, because this one is going to stay with you. Let's go back 6 hours before that clip, because to understand what you just saw, you need to understand who Marcus Cole actually is. Hargrove County, a mid-size American city. Tuesday evening, 7:42 p.m., the kind of gas station stop where nothing is supposed to happen. Marcus Cole was pulling off the interstate. He needed a full tank. He had exactly 20 minutes before his wife's birthday dinner reservation at a restaurant 40 miles north. He was relaxed. He was thinking about whether he had remembered to grab the card he had left on the kitchen counter that morning. He had absolutely no idea that in less than 8 minutes, he would be standing at the center of a recorded encounter that would be watched over 43 million times. And that would trigger the largest civil rights settlement in Hargrove County history. But here is the thing about Marcus Cole that Officer Dale Braddock had absolutely no way of knowing. Marcus Cole did not just know the law. Marcus Cole had spent 11 years on the bench as a sitting circuit court judge. He had presided over more than 4,000 cases. He had written legal opinions that were cited in federal appellate courts across 3 separate jurisdictions. He could recite the Fourth Amendment, Terry v. Ohio, and the exact departmental use of force policy for Hargrove County from memory before his coffee got cold. This was not a man who had read a few articles online about his rights. This was a man who had spent over a decade being the final authority on those rights in a courtroom. And on this Tuesday evening, at a gas station off exit 14, that background was about to become the most important thing in the room. Have you ever been in a situation where you knew you were completely right, but the person across from you had a badge, a uniform, and the assumption that you simply did not know enough to push back? Drop a comment right now, because Marcus Cole's story is about exactly that, and what happens when the person they assumed did not know knew absolutely everything. Marcus Cole was 35 years old. While most people his age were still building their careers, Marcus had already been appointed to the circuit bench at 32, making him one of the youngest sitting judges in his state's history. At 22, he graduated summa cum laude from Howard University School of Law. By 26, he had clerked for a federal appellate judge and published 2 law review articles specifically on Fourth Amendment jurisprudence, the body of law that governs exactly when a police officer can legally stop, question, or detain a citizen. By 29, he was a prosecutor known specifically for cases involving law enforcement misconduct, cases he won with a documented 91% conviction rate. He did not just understand the law from a textbook. He understood it from both sides of a courtroom, from the inside of a jury room, and from 11 years behind the highest chair in the building. He knew Terry v. Ohio, 392 U.S. 1, 1968, the Supreme Court case that defines when an officer can legally stop a citizen on the street. Cold. He knew Florida versus Bostick and exactly what a truly voluntary encounter looks like under the law versus what a coercive one looks like. He knew Hargrove County Police Department General Order 14B, the department's own written policy on pretextual traffic stops, because he had ruled on violations of it 3 separate times from the bench. He carried a small digital voice recorder on his keychain everywhere he went, not because he was paranoid, because he was a black man in America, and he had seen, from the highest chair in the courtroom, what happened to the men who faced this exact situation and were not prepared. On Tuesday, prepared made all the difference. Tuesday, 7:42 p.m. exit 14 off State Route 9, the Hargrove County Expressway, the quick fuel station at the corner of Tanner Road. Fluorescent lights buzzing overhead, the smell of rain-soaked asphalt drifting up from the earlier storm, the quiet mechanical hiss of a gas pump cycling in the background. Marcus Cole pulled his 2023 Cadillac Escalade Black, registered in his name, fully insured, current tags, not a single violation on record, into bay number 4. He was not speeding. He had not run a light. He had not made an illegal turn or any erratic movement. He had not done a single thing, not one thing, that constituted a moving violation, a vehicle code infraction, or any articulable basis for law enforcement contact. Every single thing Marcus Cole was doing was lawful, completely, documentably, provably lawful. Then Officer Dale Braddock arrived. Braddock had been sitting in his patrol cruiser in the adjacent parking lot of a closed tire shop, dark, engine running, for approximately 11 minutes. Dashcam footage from a second vehicle at the station, submitted later as evidence, shows Braddock watching the Escalade turn in from the highway. He did not run the plates before approaching. He did not observe any traffic violation. He simply watched a black man park a luxury SUV and decided that was enough. The moment Braddock stepped out of that cruiser, something was already wrong. He does not walk toward the pumps like someone conducting a routine check. He walks directly toward the driver's side door. Fast, deliberate, posture already aggressive, hand drifting toward his belt before a single word has been exchanged. He does not introduce himself. He does not explain the basis for the contact. He immediately plants himself at the window and begins issuing commands before Marcus Cole has even replaced the gas cap. Marcus Cole noticed all of it. He said nothing. He pressed the button on the keychain recorder, confirmed the red light was blinking, and waited. "Sir, this is a high-crime area. I need to see your license, registration, and proof of insurance. Step out of the vehicle." Marcus Cole paused, took one breath, and then, calmly, clearly, with the same measured voice he used reading verdicts in open court, said this: "Officer, under Terry versus Ohio, you are required to have reasonable, articulable suspicion of criminal activity to justify this stop. I have committed no traffic violation and no criminal act. Before I provide anything, please state your name, your badge number, and the specific articulable reason for this contact. I am recording this interaction." Officer Braddock blinked. He had opened with that line hundreds of times. High crime area. Step out. He had never, not once in 9 years on the force, heard a response like that. Not cited by name, not quoted with a Supreme Court case number, not delivered with that level of calm. He recovered or tried to. You can see it on the footage. He straightens, he recalibrates. He reaches for the next tool in the box. Here is what Marcus Cole just did in that one exchange. In one sentence, he established that he knew the exact legal standard required for a lawful stop under the Fourth Amendment. He named the Supreme Court case. He invoked his right to know the basis for the contact before complying. He announced he was recording. That is not something most people know how to do in that moment. That is not something most people, including many attorneys, have the composure to execute clearly while a uniformed officer is standing at their window in the dark. Braddock had just revealed, in those first 30 seconds, that he had no articulable reason. Because if he had one, the professional response is to state it. He did not state it. He changed tactics. "Sir, I'm going to need you to calm down. You're being uncooperative. Exit the vehicle or I will be forced to escalate this situation." Marcus Cole did not flinch. His voice stayed flat, measured, surgical, and he said this: "I am calm, officer. I am speaking in a normal tone of voice. Requesting the legal basis for a stop is not uncooperativeness. It is a constitutional right. Refusing to provide that basis while issuing exit commands is a potential Fourth Amendment violation. Your badge number, please, right now, on camera." Do you understand what just happened? Marcus Cole just reframed the entire encounter in real time. He identified the coercion tactic, labeling his legal exercise of rights as uncooperativeness, and immediately named it for what it was on a recorded device. He then restated the specific constitutional violation being committed in plain language. For the first time in this encounter, Braddock is not the one running the script. The body camera footage, which Braddock was wearing and which was running, shows what happens next. Braddock looks away, not a glance, a full look away from Marcus Cole, over his shoulder, toward the empty parking lot. Like he is looking for backup that is not there. That is the moment. Right there. Watch the footage. That is the moment he knew this was different. Braddock tried something else. He decided to reach for authority rather than law. He leaned in closer to the window, lowered his voice, which is its own form of intimidation, and said this: "You are making this a lot harder than it needs to be. I can detain you right here for as long as I want while I figure out what's going on. So you can either cooperate or you can spend the next 2 hours on this curb. Your choice." Silence. 3 full seconds of silence that, in the footage, feels longer than 3 minutes. And then Marcus Cole said the words that would end up being replayed 43 million times across every platform on the internet. "Officer Braddock, Badge 774, I can now see your nameplate. What you just described is unlawful detention without probable cause, which violates the Fourth Amendment, the 14th Amendment, and specifically Hargrove County Police Department General Order 14B, Section 3, which explicitly prohibits pretextual pedestrian and vehicle stops based on race or vehicle type. I have committed no crime. You have no probable cause. You have no reasonable, articulable suspicion. This encounter is being recorded in its entirety. You have two choices. You state a lawful basis for this stop right now, or you return to your vehicle. Those are the only two options available to you under the law. What Marcus Cole just cited is not an opinion. It is not attitude. It is not aggression. It is the Fourth Amendment of the United States Constitution. It is General Order 14B, a policy written, adopted, and distributed by the Hargrove County Police Department itself, Braddock's own department. It is Supreme Court precedent. Every single thing Marcus Cole said in that 30-second statement is verifiable, documentable, and legally accurate. It cannot be argued. It can only be documented, and Braddock knew it. The body camera captures it in real time. You can see his jaw tighten. You can see him look down at the ground for a full 2 seconds. You can see his hand come up toward his belt, not reaching for anything, just a nervous reflex, and then drop back down again. He had no response, not because he was speechless, because there was no legal response available to him. What Marcus Cole had just built, in 90 seconds at a gas station pump, was a case. A documented, time-stamped, recorded case, and Braddock had just walked straight into it. But then Braddock made the mistake. The one that turned a bad stop into a career-ending incident. He reached for his handcuffs, not because Marcus Cole was threatening, not because there was a weapon, not because any law on any book in any jurisdiction gave him the authority to do what he was about to do. He reached for the handcuffs because he had lost the argument and he still had a badge. He said this: "Turn around. Hands behind your back. You're being detained for obstruction." Marcus Cole looked at the handcuffs. He looked at the body camera on Braddock's chest. He looked directly into it, directly into the lens, and said one sentence: "This arrest is unlawful. I am complying under duress and I do not consent. Everything is on record." He placed his hands behind his back. He did not resist. He did not argue further. He let it happen. Because Marcus Cole understood something that most people in that moment do not understand. The most powerful thing he could do in that moment was comply, stay safe, and let every single second of what was happening burn itself into that recording. He was not losing. He was building. Every second those handcuffs were on, the lawsuit was getting larger. The encounter ended 19 minutes after it began. A second officer arrived, reviewed the scene, and within 4 minutes, the handcuffs came off. No charges were filed. No basis for obstruction was documented in the incident report. Braddock walked back to his cruiser. The other officer left, and Marcus Cole stood alone at bay number 4 of the quick fuel station at the corner of Tanner Road. He did not celebrate. He did not call his wife in anger. He pulled out his phone, confirmed the recorder had captured every second, sent the audio file to a secure cloud backup, and then, before the cruiser's taillights had even disappeared, began dictating notes into his phone about every detail of the encounter: timestamps, names, body language, specific statements, verbatim quotes, the exact sequence of events in chronological order. That tells you everything about who Marcus Cole is. Most people, after something like that, go home shaking. They call their family. They post something on social media. They are angry for a week and then life moves on and Officer Braddock moves on too. Marcus Cole did not go home shaking. Marcus Cole went home focused. What he wrote over the next 4 hours was not a complaint. It was a legal brief, a comprehensive, methodically organized, formally structured legal document that read exactly like what it was: the work of a sitting judge who understood precisely what had happened, precisely why it was wrong, and precisely what the remedy needed to be. The document included a time-stamped breakdown of every statement made during the encounter, cross-referenced against the specific law or departmental policy it violated. It included a formal citation of General Order 14B with the exact subsection numbers. It included audio transcription from the keychain recorder with timestamps. It included the dash cam footage from the second vehicle, which a witness had already agreed to preserve. It included a citation of 3 prior civil rights cases decided in Hargrove County courts, 2 of which Marcus Cole himself had presided over, that established direct legal precedent for what Braddock had done. And it included a formal demand for investigation, suspension, and a systemic review of Officer Dale Braddock's full 9-year record of traffic and pedestrian stops. Marcus submitted the complaint to the Hargrove County Civil Rights Division the following morning at 9:17 a.m. He simultaneously filed a parallel complaint with the State Attorney General's office and sent a courtesy copy, with the audio recording attached, to the editor of the Hargrove County Gazette. Then he went to work. Because Marcus Cole had a full docket that morning, he had 4 cases to hear. He put on his robe, sat down in his chair, and did his job. The Civil Rights Division received the filing at 9:45 a.m. The director read the first 3 pages and called in her deputy. The deputy read it and called in the division's chief investigator. By noon, all 3 of them were in a conference room with the recording playing on a laptop. This was not a normal complaint. They all knew it. The level of documentation, the legal precision, the specificity of every cited violation. This had been prepared by someone who did not just know the system, someone who was the system. They opened a formal investigation that same afternoon. Within 72 hours, Officer Dale Braddock had been placed on administrative leave pending investigation. The investigative team pulled his full body camera archive going back 2 years. They pulled his stop and search records going back to his first year on the force. They brought in an independent civil rights attorney to review the documentation Marcus had submitted alongside their own findings. What they found confirmed every single thing Marcus Cole had documented. The stop had no articulable legal basis. The command to exit the vehicle had no legal justification. The detention had no probable cause. And the charge of obstruction was, by every applicable legal standard, completely fabricated. But the investigation did not stop there, because once the team started examining Braddock's full record, a pattern emerged that no one in that department could claim they had not seen before. Over 9 years, Braddock had conducted 47 pedestrian and vehicle stops in the county. 39 of them, 39 out of 47, involved black male drivers in vehicles valued above $30,000. Not one of those 39 stops had resulted in a valid citation or arrest. Not one. In every single case, the stated reason for the stop in the official report was either high crime area or suspicious vehicle behavior. In none of the cases was the specific suspicious behavior described. In none of the cases was a traffic violation documented. Braddock had been running the same play for 9 years. And before Marcus Cole, no one had been positioned, qualified, or prepared enough to document it properly. Marcus Cole's case was not just one incident. It was the incident that finally opened a file that should have been opened 9 years ago. And every one of those 39 men, 39 people who had been pulled over for driving a nice car while black, was now part of an expanding civil rights investigation that Marcus Cole had set in motion with a keychain recorder and 4 hours of focused legal writing. The Hargrove County Civil Rights Division released their findings 26 days after the initial filing. The report was 61 pages long. It found that Braddock had violated the Fourth Amendment in the Cole stop. It found he had violated General Order 14B on at least 11 documented occasions across his career. It found that supervisors in his chain of command had received prior informal complaints about his behavior and had failed to act. And it found that the department's own training and accountability mechanisms had failed systematically over the course of nearly a decade. The recommended action was immediate termination. Officer Dale Braddock, 9-year veteran of the Hargrove County Police Department, was fired. His certification was referred to the State Police Standards Commission for formal revocation. 2 supervising officers who had received and ignored prior complaints about Braddock were formally reprimanded and removed from supervisory positions. And the department was ordered to undergo mandatory retraining on pretextual stops and Fourth Amendment compliance. Curriculum to be developed in consultation with an independent civil rights organization. Marcus Cole's attorney filed the civil lawsuit 6 weeks after the investigation concluded. The complaint named Officer Braddock, the 2 supervisors, and Hargrove County itself as defendants. It alleged Fourth Amendment violations, 14th Amendment equal protection violations, unlawful detention, civil rights violations under federal statute 42 United States Code, section 1983, and a pattern and practice claim against the county based on the 9-year record of documented stops. The county's legal team reviewed the filing. They reviewed the audio recording. They reviewed the 61-page investigative report. They reviewed the dashcam footage from the second vehicle. They reviewed Braddock's full 9-year stop record. They reviewed the 39 prior stops, none of which produced a single valid citation. And they did what any rational legal team does when they are holding 61 pages of findings, 40 minutes of audio, and a plaintiff who is himself a sitting judge who will be able to testify with more legal precision than their own attorneys. They called Marcus Cole's legal team and asked about settlement. The negotiation lasted 11 days. The final figure was $13,800,000 paid to Marcus Cole by Hargrove County. It was the largest civil rights settlement in the county's recorded history. In addition to the monetary figure, the settlement included a formal written public apology from the county, a court-monitored reform plan for the police department's stop and search practices, mandatory body camera review protocols for all officers, and the establishment of a civilian review board with actual investigative authority, something civil rights advocates in Hargrove County had been requesting for over a decade and had never received. When the settlement was announced, the footage was already everywhere. It had been shared by legal analysts, civil rights organizations, law professors, and former law enforcement officers who used it to demonstrate exactly what unconstitutional police conduct looks like and exactly how to respond to it. Law schools added it to their curricula. Police academies added it to their training programs. Every constitutional law professor who reviewed the footage said the same thing. Marcus Cole was correct on every single point. Not approximately correct, not mostly right. Correct on every single legal citation, every procedural point, every stated violation. All of it was accurate, all of it was documented, and all of it held up to scrutiny from the moment the recorder started blinking to the moment the county signed the settlement check. Let's talk about what this story is really about. It is not about Marcus Cole versus Officer Braddock. It is not even about this one stop at one gas station on one Tuesday evening. It is about the gap, the enormous, consequential, sometimes dangerous gap between what people know about their rights and what systems are built on the assumption that they do not know. Law enforcement authority in any context relies on a certain level of public compliance, not unlawful compliance, not blind compliance. But the quiet, statistically reliable fact that most people, when confronted with a uniform and a command, simply do not know the precise legal standard required to make that command lawful. They do not know Terry v. Ohio. They do not know what articulable suspicion means. They do not know their department's own general orders. And so the command works. Not because it is right, because it goes unchallenged. Marcus Cole was not louder than Officer Braddock. He was not angrier. He was not bigger or more intimidating. He was simply more prepared. He knew the law that governed that exact moment, better than the officer who was there to enforce it. And that single fact changed everything. The badge did not win. The robe did not win either. Knowledge won. Documented, cited, recorded, filed knowledge. That is the takeaway from this story that matters most. There are things you can do with this. Write down the name Terry v. Ohio and look up what it actually means. Understand that in this country, an officer must have reasonable, articulable suspicion of criminal activity before conducting a stop. Not a hunch, not a neighborhood, not the value of your vehicle. Know that you have the right to ask for a badge number, a name, and the stated reason for any law enforcement contact. Know that you are allowed to record in any public space. Know that if you are detained, you can state clearly that you are complying under duress and do not consent, and that statement is legally meaningful. Know that if your rights are violated, there is a process, a complaint, a filing, a record, and that process has teeth when it is used properly. Marcus Cole was not trying to be famous. He was not trying to make a statement. He was trying to get his wife's birthday dinner reservation on time. He was thinking about a card he left on a kitchen counter. He had no interest in becoming a story that 43 million people would watch, but he was prepared. And in 19 minutes at a gas station on a Tuesday night, preparation was the difference between a man who was humiliated, silenced, and forgotten, and a man who changed a county, ended a career, opened a 9-year investigation, and walked away with $13,800,000 and a story that still gets told. The people who hold power accountable are rarely the loudest in the room. They are rarely the most connected, the most resourced, or the most visible. They are the most prepared. Marcus Cole's story is proof of that, and it is still being told. Subscribe for new stories every week. All of them real in their lessons. All of them documented in their truth. Like this video if you believe that knowledge is the most powerful thing a person can carry. Share it because someone in your life needs to hear this story today. And drop a comment. Where are you watching from? And what is the one law or right you wish you had known earlier in your life? I read every single one.